More just to get you you're a little bit better. You got it right there.
And preview the broadcast. Go live. Waiting for the video. Okay, we'll just see if everything's working, ladies and gentlemen. We'll be there in a second. And once that's set up, if you can hear us, then we will okay. Okay, we are. Why isn't Facebook working at the moment? Okay, we are on. Show you that. Okay, let's go to here, there. Okay, so that's LinkedIn. That's live now. So it's saying it's live there. We'll just have to just trust with it, and then it's working. So, ladies and gentlemen, welcome to the broadcast for today. It is a. We're hoping you can see this. Go live now. If you can hear us and see us, that's awesome. And we want to make sure that you can hear us loud and clear. We are broadcasting to a number of channels today, but we just wanted to make sure that we've had a few issues this morning with our internet. So please forgive us, and we shall hopefully you can interact with the with what we're doing. So anyway, we're going to start. I think we've got a few issues here that we need to fix up, but if you can message us, if you can see us, that would be really good too. So I think we are broadcasting live on Facebook, so thank you, Peter, for that. And we can hear you, thank you. We're doing it via Twitter as well, and we can see that is also working. And on Facebook, it's good, and via YouTube, hopefully people can see that. But welcome to today. What we're going to do is walk through. We know that everyone is talking about a treaty. We know that that the Commonwealth of Australia itself admits that it does not have a treaty with the Indigenous people of this continent. And today we'll be discussing that in length through the Attorney General is here, Ganyara of Yalmabara, myself in capacity as acting as the Foreign Affairs and Trade Minister for the Yidindji government, and we will be talking about those things today. But Ganyara, let's talk about the treaty. We've got a few things lined up here. 3 years ago, we, as the Yidindji government representatives, travelled and met with the highest office in the Commonwealth of Australia in terms of the Prime Minister and Cabinet, and we delivered by hand, face to face, and had a meeting there, a roadmap to a treaty and what that would look like. We're going to go through some of that today, and we'll see how we go with that. Now, just bear in mind, an apology in advance. We are running this internet off a phone, so usually the office one is in full swing, but for some reasons there's some issues with that, so we've had to resort to this. But thanks for your patience, and Ganyara, I might start with we'll go with you talking about this treaty stuff.
Yeah, look, thanks. You've got to ask the question, why was there no treaty for a start, and why is there a need for a treaty? The first part with all this is, basically what is a treaty? A treaty is just a formal agreement. So when the colonisers went out around the world, the colonists went out, they normally done a treaty, as they did in New Zealand and in Canada and in the US. They were everywhere. Treaties were very commonplace at the time. However, when it came to Australia, it was the anomaly. Why didn't they do one here? Why they just think that they could just move in and take over the place, which is really the problem for Australia. It's not our problem per se. Our problem is that we have these people intruding upon our territory and our law. So we've got to work a way forward now out of this. How do we go forward from here? Because we have 24 million unlawful non-citizens, if you want to call them that. They call them Australians. And we have roughly the million people of Aboriginal or Island descent here, whose law, by the way, law and custom still is present, is still here. So the only way forward out of this now is a treaty, a proper treaty that should have been done, roughly 120 years ago, at the latest, when the Commonwealth of Australia came into existence. So a treaty is just a formal agreement. It's the way we work forward. Who's going to be doing what. It shows who's got the mutual rights and obligations. What are you going to be doing? What are we going to be doing? But the main question to ask is, who can offer the treaty? Can the Commonwealth of Australia offer us a treaty, or do we offer it to them? And because they're upon our territory, they've got nothing really to offer us. It's our territory that's at stake. It's our law that's at stake. So we offer them. We have to offer them a treaty. It's up to them to agree to accept it or negotiate the terms and conditions, which we would rather happen, because both parties have to negotiate what's going to be the best for both societies. Now, when the Australians moved in, they actually didn't kill the law of the Aboriginal people. The law was still left there. So that left these coexisting sovereignties that's acknowledged by the Uluru Statement from the Heart. With that, we can't have competing sovereignty. We can't have two sitting side by side, because ultimately one has the right of way and one doesn't. And in this case, the law of the Indigenous nations, of the Aboriginal and Torres Strait Islander nations, has the right of way. That is the one who is superior, because it's standing in time. So the reason we need to have a treaty is Australia needs it. We need to be able to work out how we interact with these other 24 million people that are on this great continent here. And they can't force us into a treaty, just like we can't force them into a treaty. Because remember, we've got to come together as equals, and we've got to negotiate about all this, what we're going to do, who's going to be doing what. So that has to be done voluntarily and with consent. And both sides have to consent to that. So that is really the important part about this. So that's the start of a treaty. As we said, we have to offer the treaty. They got no real ability to offer too much to a treaty, other than their administrative ability. And believe it or not, once we start talking like this is starting to is in keeping with the protocols of the UN Declaration of Rights for Indigenous People. And that's a very important part to remember, because in this situation, the Indigenous people, as in the Aboriginal people here or the Yidindji people, we'll talk very specifically, have the right to participate in the life of the state if they choose under Article 5. What if we don't so choose? You know, so if we're going to exist in our outside world the way we should, Australia cannot interfere with what we do with our law. So, but they're upon our territory. We've got to have this work. We've got to work it out.
All right, we've got a few definitions up here on the screen for people to have a look at. Now, these definitions are also quite similar in the Yidindji legal dictionary, which the Yidindji government, through your office, actually, Ganyara, created to help with definitions on the Yidindji territory. And I think it's very important that people consider that when that they define the things that are important to them in a legal sense. So let's have a look. What is a treaty? And you can take it. Yeah.
Well, look, a treaty is just an agreement, a formal agreement that's between two nations or sovereigns. Now, remember, the Uluru Statement from the Heart said there are coexisting sovereignties. So we said, okay, no worries. We knew this all along. So it's got to be between us as a sovereign nation and the Commonwealth of Australia. So it's just a formal agreement between these things that just define, you know, the mutual duties and obligations, I suppose, the rights and obligations that each party to the treaty have to abide by. You know, so you can say there's no real definite form to it, but it's how we want to bring it forward. So when we go forward to do this, a treaty with us might be different to the treaty with the tribe next door or the lot next door, the nation next door. So there can be different things in place, different looking treaties.
Yeah.
But a treaty is an agreement. That's basically it's a contract. It's as simple as it is. But it's done, treaty in the true sense of the word is done between sovereign entities. And that's the coexisting sovereignties, that of the Aboriginal people and that of the Commonwealth of Australia. Now, when we have a look at position in law, we were first. There's no ifs and no buts about that. So we have to offer Australia the treaty. Now, I think you'll find on the next, I did put a thing there about who needs the treaty, and it's not us that needs the treaty, it's Australia. But we go to the Uluru Statement with regard to that, and it actually this is made very clear. The Uluru Statement was put together by the best minds, constitutional and Indigenous law minds that Australia could find at the time. That was in 2000. It culminated in 2017 with the Uluru Statement. Now, these are the best people in constitutional law, and they come forward and said, look, the Aboriginal and Torres Strait Islander tribes are the first sovereign nations on the continent, on the Australian continent.
Yes.
And it's adjacent island, and they possessed it. And we possessed it under our own law and custom. Now, remember, our law and custom is not the law and custom of Australia.
Or Britain.
Or Britain or anywhere else. There's two separate things out there. There's our law, and then there's their law. This is where the sovereignty coexists. But we were here from time immemorial, if you want to call it that. We knew it was from day one. Whatever it is, we were here first. We like just say, look, we were pre-1770 when the colonial world moved in on our country. So we were first. And that's still here. We're still here. Now, there's a lot of documentation about all this out there in the big wide world. There's actually quite a good book put out by Cheryl Saunders and what's her name? Adrian Stone.
Oh, okay.
Dare Stone, the Oxford Handbook on the Australian Constitution.
Okay, well, let's have a look at that.
Yeah.
And we'll switch to that.
Yeah.
So people can see it.
Yeah, have a look down there. It's just there.
Mm-hmm.
Whether the legal paradigm used to explain colonisation is conquest, cession, or settlement, the reality is the colonisers were the intruders. So that's a pretty hard position to be stuck in. The Australians are the intruders.
Now remember, it's very important to comprehend that the Yidindji nation isn't the one making these claims or statements. It is totally the foreign entity known as the Commonwealth of Australia and its agents that are the ones that are talking about this. And so that's a very important thing to remember.
So do we as the Aboriginal nation need the treaty? Because we've got permission to be here because we were first, we were just always here. Or is it the Commonwealth of Australia that need the treaty? This is the point of all this.
Well, did Yidindji intrude on itself?
No, we are, and we're not part of Australia because we're excluded. But the Commonwealth of Australia is the intruder. There's no ifs and no buts about that. They acknowledge that, and these are done by very intelligent people. This book is quite a good book to read regarding that. So it's the reason why we need to have a treaty is to let Australia be here, let it be upon our territory. So there's been a lot of prime ministers talking about this stuff. Paul Keating called it unfinished business. There was this one here, a news article put out and in the Guardian going back a few years. So why the need for a treaty? Because there was a mistake when the Constitution was framed, at its inception, in the late 1890s to the very early 1900s. There was a massive mistake. The massive mistake was to leave out the Aboriginal people, to exclude them.
Yes.
It was the white Australia policy. Now that's not our doing, it's their doing. But we're the only one who can remedy their mistake. We're the only one who can remedy their wrong. And we have to maintain two very separate entities, the sovereignties that coexist. So we've got to ensure that we stay in our correct capacity and they stay in their correct capacity. We are not Aboriginal Australians. No way, because we're not Australian. We were excluded 100% from Australia. So the need for a treaty is to let these two coexisting sovereignties, of which Yidindji is the highest, to how these two are going to interact together. How the Australian and the Yidindji sovereignty is going to be on this great continent here. And it's the only way this can work. That is why there is a need for a treaty. That's the only reason. We don't need the treaty ourselves. Australia need us to offer them a treaty. They need the treaty. They need consent. They settled here, as John Howard said, we settled here without treaty or consent. How much more clearer does it have to get than that? And yes, look, we were excluded.
We've got some interesting... once again, we're going to use the evidence of the Commonwealth of Australia that says this stuff.
Their stuff, and they can see it. See, we could put our definition up from the Yidindji dictionary, for example.
Yeah. And
that's our right to make our legal dictionary. And the rest of the world can see how we see words. But we like to use their evidence because they can't refute their evidence. Now, a lot of their evidence is produced by constitutional lawyers or in courts or whatever. So were we excluded? 100%. And why were we excluded? We were excluded because Australia could dictate who it wanted to be part of its world. And they really could. So if you go to the National Archives of Australia, there's a little document called the Constitution for a Nation. It's not, I wouldn't call it court-grade evidence, but as it says there, the people were included in the preamble of the 1897 draft Australian Constitution as an expression of its creators' democratic ideals. However, the people referred to in the Australian Constitution of 1901 did not include the Aboriginal and Torres Strait Islander people. Now that's pretty how could you say, pretty obvious. And that is why, it just went on for so long now. A number of people, constitutional lawyers, have produced books, a lot of documentation on this, and the likes of George Williams, Sean Brennan, Brent, they're experts in their field. They're experts in constitutional law, which is something we say, we understand, but when you read this, as they wrote a book called Treaty. Now, this has been upgraded from, they wrote one book, Treaty, going back a few years now, and they've upgraded that, or updated it, to Treaty again. As they say there, though, even when Australia became a federation, Indigenous peoples were excluded from the moment of nation building. We were excluded, we're never part of it.
May I interrupt you there, because I know that we've got people watching this from what people would understand or describe as Canada and New Zealand. It's very important to know what we're talking about also is capacity. So a native Canadian or an Indigenous Canadian or a First Nations Canadian can't treaty with Canada. The same way that an Indigenous Australian can't treaty with the Commonwealth of Australia, the same way that an Indigenous New Zealander or a Maori New Zealander can treaty with the Commonwealth of New Zealand.
Well, you're right. And that's why we're just showing here capacity now.
In terms of that nation-to-nation sovereign treaty.
Absolutely. If we were part of Australia, as John Howard said very correctly, going back, a nation can't treaty with itself. But we were excluded, as is very clearly shown. We were excluded. Now, there's can Australia dictate who takes part in Australia? Absolutely, they can, because in this court case, Wang versus the Commonwealth and Fu versus the Commonwealth, every sovereign country has the undoubted right to determine who shall enter its country and constitute the political membership of the community of that country. Now, in saying that, they said to us, you can't take part in our world. It's their right to do that. Their right. We can't force ourselves into there. So it's every right for it's every sovereign nation has a right to determine who its citizens are going to be,
yes,
what privileges they're going to have. So that's all right. It's only membership. But they got to offer us membership because we have a choice under Article 500, the UN Declaration of Rights of Indigenous People, to take part in the life of the state if we so choose. But they're on our territory. So we're going to act as Yidindji. It's all about capacity. We are Yidindji. Right today now, we are Yidindji. Everything.
Yeah, I think it's really important that the authority and the power that's, that the tribal nation has is unscathed, and on this continent, that is. And the ability to grant consent is quite a powerful application and exercise or assertion of one's sovereignty. And once again, Brennan, Berendt, and Strelin and Williams have talked about this again. Let's have a look at this one.
Well, as you can clearly see, these are constitutional lawyers from within Australia, and these are experts in their field and quite good ones at that. But as they correctly said there, they took control of the continent, of the land mass itself, without treaty or consent. They didn't have consent from our lot, for example, to be here. They didn't have a treaty with our lot to be here. So that's the word colonisation. They moved into our house. It's still our house. And then they just asserted complete control over all the things that they thought were theirs. They took everything without compensation. We were excluded 100%. There's no ifs and no buts about it. But the problem is this other, now that it's been acknowledged as existing, is this, you want to call it natives titles? Call it whatever you like. It's this indigenous law and custom that forms or constitutes sovereignty is the problem for them. The sovereignty of the nations, of the indigenous nations, the Aboriginal nations. Now, they thought that they could do it as settlement. There would be no other rival, or pre-existing sovereignty, but there is. And that's been shown by the High Court of Australia. The High Court rejected the terra nullius doctrine, that there was no one here of capable or quality of having sovereignty. They've acknowledged that was all wrong. So now we've got this coexisting sovereignty called Yidindji or the other, Kunjun or whatever else there is, all the Aboriginal nations.
And it's a serious matter because the word consent is extremely powerful. If you were to, for example, court a woman or a partner or a potential partner, and you did not have their consent to conduct certain activities, then that can be a serious matter before any court. If you wanted to be with a woman, for example, and you did not get her consent, then that's extremely serious. Here, the issue of consent is extremely serious, and the Commonwealth of Australia has to take Yidindji's assertions quite seriously, and anyone else who does that in the correct capacity, especially with an offer of consent for that political and legal intercourse to take place between nations or legal personalities, for example.
Well, it all comes back to here. Capacity, everything. It's where your legal identity is created. Now, as they said to us, you can't take part inside Australia because of the White Australia policy, basically. You don't take part.
Fair enough.
And that's all right. That's their right. As you can see under case law inside Australia, they can determine who wants to be part of Australia. They said to us, you can't take part.
Yep.
So that left us only one option. And the option was to create our legal and political identity through our constitution, our law and custom that was here first. The problem for Australia is us being first meant they were second. And that comes down to who the real owners of the place are. If we are the real owners of this continent under our law and custom, which they acknowledge as existing, means that what are they? Are they the owners or are they the intruders? You see, this is the problem. If they're intruding on our territory, they should be subject to our law and authority. And that can be very much the case. So Australia need this. They need this because we're not acting as the Australian citizen anymore. We're acting through our identity, our legal personality, our citizen. And that's how we're seen legally through our world. And when we go and interact with Australia, for example, we are seen through that. By doing so, we're outside of the Australian law because the Australian law is subject to the Australian Constitution. It is the overall everything, the Constitution, that allows the creation of the law of Australia. And that includes the creation of a legal identity of the person, of the citizen, through the relevant, or the state's relevant Birth, Deaths and Marriages Act. So we're not part of that. We were never part of that. We were left right out. So our capacity is now created subject to our Constitution, not the Australian one. And that's our right to do it under our sovereignty, the one that was here prior to 1770, prior to the British coming, prior to Australia being formed. We were first, our stuff is there. So that's a pretty basic sort of concept to get. And you've got to understand that it's all about membership. Can we take part in that club called Australia, Commonwealth Australia? So we're saying, okay, we will negotiate a position where we can coexist side by side. And that's a very important part.
Well, let's look who the real owners are, which is another important thing. The Yidindji nation knows what it possesses, but it's very interesting when other people say what agree to that.
Well, especially when they are Australian constitutional lawyers producing this stuff.
Yeah, it's not, old mate down the road on the corner. These are people who have taken a law and constitutional law very seriously. They've studied it for years, and some of them have gone to the greatest institutions in terms of the UN realm, maybe Harvard or Oxford or, the ANU or wherever they may have gone. So this is quite a prestigious position that they hold inside the Australian society or the legal fraternity.
Well, absolutely. Look, as we said, there's a basic book out there. It's not a real big book, but put out by these four constitutional lawyers called Treaty. The Indigenous peoples, as the prior owners and occupiers of the continent, feel a strong sense of exclusion from the Australian state. And that is very much so it is. They are very much left out. And for that reason, believe that it lacks legitimacy. And it does lack legitimacy unless you're being an Aboriginal Australian. Then it has legitimacy. They point to basic flaws in legal logic by which we govern ourselves in Australia, the flaw being there from the beginning. That's where that they said you can't take part. So look, the Aboriginal people were never part of it. And a flaw that even Prime Minister John Howard himself acknowledged, this land and its waters were settled as colonies without treaty or consent. See what I mean? This is the Australian Prime Minister saying this. This is these constitutional lawyers saying this. And then there was another good book put out by Megan Davis, Professor Davis and Professor George Williams, called Everything You Need to Know About the Referendum to Recognise Indigenous Australia.
There you go. There's the text on the screen there.
Yep. Once again, they were talking about the sovereignty of the Aboriginal nation. The only page that really matters to us is page 121. And as it says there, this is brought about by the assertion by the British of their sovereignty over the Australian continent. All this occurred before the Australian Constitution came into force in 1901. That document created a new nation upon a continent that the British already regarded as theirs. Changing the Constitution in 1967 did not alter this, nor would changing the Constitution again today. This, of course, represents the position under Australian law of which the Constitution is the ultimate expression. It does not affect how Aboriginal people view their own sovereignty. As a result, it does not prevent them from asserting their own independence and continuing validity of our laws and customs. Understand this stuff. If we take part in Australia, we've limited ourselves. But if we take part in our law and assert our sovereignty, the one that's been acknowledged as existing or coexisting alongside that of Australia, whose law is now whose law is has right of way, whose sovereignty has right of way now? And it's ours. And look, the Federal Court of Australia, through numerous native title determinations, has reinforced this position that we have the ownership of the place, we have the land rights, we have everything. So no matter what Australia do, because they were talking about saying we'll recognise Aboriginal people inside the Australian Constitution. As we kept saying, who cares? It's got nothing to do with us. We were excluded. So the Constitution of Australia, nothing to do with us. We're out. We're on the other side. We're the coexisting sovereignty, the one outside Australia.
That they acknowledged exists.
Absolutely.
So, once again, the whole recognition debate is, from our point of view, is done and dusted. It's very important that I put this across today, that the Yidindji nation and its territory cannot and will not be usurped by the Commonwealth of Australia or anyone else for that matter. It has been proven, not in our world, we don't have to prove it, but other people have said inside the Federal Court of Australia and other determinations in there that Yidindji own the place, the land pursuant to their law, and the Yidindji know where its boundaries are. And that's very important, because if you're not with Yidindji and you're not with the Commonwealth of Australia, then which law system are you under? Because you might be outlawed. And so I think that's a very important discussion also. But this roadmap to a treaty is very, very important, because the Commonwealth of Australia requires a home. The Yidindji are happy to provide that under certain terms and conditions